Well, welcome everybody to the Raising Capital Seminar Series. This is our fifth module today. As you're all getting settled in, if you would, we'd ask that you go ahead and turn on your cameras. We'd like to see you today, if you can, if you're in a situation where you can do that. For any of you who have tried to do instruction over Zoom, not being able to see anybody makes it really challenging. So again, this is module 5. We're going to cover the term sheet today. And I tell people why this is so important. It's because it determines how much money you get out of your company. And believe me, as we found out in the cap table example, one little word can have a huge effect on how much money you get out of the deal versus your VC, your angels, and others. Joe Leo, you can read the bio. I've known Joe for 10 years or more. I consider him a friend. He has been involved with innumerable startups in the local scene, and he's practical, pragmatic, and knows his stuff when it comes to securities law. He also is a member of a rock and roll band, which is pretty cool. This is a collaboration. What's that?
Thanks. That'll give me some good information if we need to get people's attention back. So I appreciate that.
Yeah, just hit a drum or play a guitar for us. That'll really get us going. This is a joint collaboration of the Greater Des Moines Partnership, LWBJ, and Brown Winnick Law. And so the three of us worked together on this. And this is actually the first year we split it up into 5 modules. And the feedback so far has been very positive. So again, thanks for joining us. Mute your microphone, and it looks like everybody does, but leave your video on if you can. We really appreciate that. What I really need you to do now is open your chat window. If everybody can do that for me, because we're going to be sharing some documents with you this morning. Now, you will also get an email, and you probably already have an email, but I'll be sending it again to everyone. There's a link to where all of this stuff is stored. So there's one location on the web at our partnership website where we've stored all of this. And I'm going to be, after Joe gets going, I'll be sharing 3 documents with you this morning. The presentation today, if you want it right away. The appendix file. I actually rebuilt the entire appendix. It was like this 100-page document that was kind of ridiculous. It's now a 1-page document full of links sorted by subject area. So it's a lot easier to handle. So I'll be passing that on. And then let's see, appendix, the presentation, and actually the term sheet. That's the National Venture Capital Association term sheet. Joe's going to refer to it, but it's just something that is a standard term sheet, and it may be of help to you. Again, there will be a recording of this, so we are recording you, fair warning. And so this is, again, module 5, and we'll probably not go past 10:30. I would doubt we'll go past 10:30, but it really is up to you. We're here till 11:30, so if you have questions, we're here to answer them. And with that, I want to unshare my screen. And Joe, you want to go ahead and share your screen for us?
Absolutely. So
I'll turn it over to you.
Hopefully everyone can see my my PowerPoint. I'm just going to bring that up. So good morning, everybody. Thanks for coming and for taking the time today. I'm Joe Leo. I work at Brown Winnick, and I work with a number of kind of early stage companies and help them with things like capital raising, and also I take confession at a lot of times with them. When you work in this area, there's always a lot of questions that you get that are not purely legal, and so I think the most rewarding part of my job is that I get to be at some level involved with a lot of companies in the early stages, which I find pretty exciting. So I'm going to go through my slide deck, but I will tell you that I'm happy to take questions at any point that you have them. Feel free to just unmute and ask a question. I know that the chat screen will be up, so if you hit something in the chat screen, also raise your hand so it helps me to keep an eye on you and make sure that I can answer your questions when you have them. So just FYI on that. I actually, so I've been teaching a law school class via Zoom this year, and so I feel like I'm getting marginally better at talking to larger groups of people on Zoom. But feel free to interrupt. I'm used to it, and I can get back to the material as much as I can. So we, as Mike said, he'll be sharing in the comments. There'll be a term sheet that we have that's just informational for you. I can tell you that unlike when I first started doing this, there are a ton of resources out on the web on term sheets. There's the National Venture Capital term sheet, which is a standard that most people use. They also have the Cooley Go documents, which are called the Series C documents. And those would be the two that I think that we see the most commonly. My presentation is going to kind of focus on a lot of those terms that you'll see in there as standard, because I think that they've become sort of the industry standard on what sort of terms that you have in a term sheet. But there are numerous other versions and changes and those kind of things that you can find on the web. And I don't consider those to be in any way proprietary. They've become sort of one of those things that I was talking to a client just the other day about filing a term sheet and preparing one. You can find a lot of things on the web. The one thing I would tell you to be careful about if you do that, and this is the only probably real significant warning that I'd give you about resources that you find on the internet is really two things. One, make sure that you're working with somebody who knows what's common in the investing groups that you're in. I've seen this a number of times where people have gotten resources off the internet, and it'll include terms that aren't, what lawyers would call market, but are really standard for your area. And that does change. There are terms that are standard in Iowa and the Midwest that are different than terms that are standard in other communities. And knowing that is important. But I can tell you is be a little bit careful and make sure that you're consulting with people who know what's common in your area before you just grab something off the internet, just because there might be things that you've put in there that are, would tell an investor that you don't have a good appreciation of what investors look for in your area. And then the second kind of caveat that I'll give you that I think is really important, and I tell clients this all the time, is really kind of a two-part. Simplicity is your friend, especially early on in your investments, in your first rounds of investment. The standard that most people go by is anything that you give an investor in an early round, you're going to have to give to the later round investors plus some. And, it goes back to this idea that you don't want to be negotiating against yourself. So don't add complexity into your term sheet early if you don't have to, right? Don't put terms in there that an investor either doesn't want or hasn't asked for or aren't common for your area. And the reason for that is that it can really make your company more complicated than it needs to be. And also it, as we saw last week when JD did a great job of going through, kind of liquidations. I think most of the people that I'm seeing on the call were participating in that. There can be sort of unintended consequences and situations that you'll find yourself in that you really didn't think about at the time. And complexity, I think, just increases the likelihood that happens. So I will tell you, the internet is a great thing, but make sure that you are relying on people who know what's common in your area. Be it in other investors. Mike is a great resource. I'm happy to help. JD obviously as well. But do that, because I do think that it's there is some difficulty there when there's all this information out that you can sort of link up with the wrong things. So that's my PSA for today. There's a star, the more you know, and we will jump into the actual presentation. So what is a term sheet? A term sheet, is just a document that outlines the basic terms where an investor might be interested in investing in your company. It is not, if done correctly, should not be a binding legal document. It should be sort of the feeling out point where you propose terms to a potential investor, and the investor considers those and comes back and makes a decision if they want to have further conversations with you. So for the most part, all good term sheets should be non-binding, with a few exceptions that we can talk about here in a minute. But The reason you don't want to have them binding from a purely legal standpoint is that they typically don't have the level of detail that your attorney is going to need to help you protect the company, right? You don't want to be locked into terms if some other issue comes up later in the actual legal documents that you can't negotiate through. So I get this question sometimes from clients. They say, well, Joe, what's the value of having a term sheet then? If I'm not locking in an investor by having them sign a term sheet, what's the point? And the point is that it is really twofold. One, it helps you to understand whether you're in the ballpark where you can actually negotiate with an investor, right? If I have a client who delivers a term sheet to somebody and they're worlds apart in the terms that they want, valuation, and you can't get them on the same page, it's a less expensive way to find out that you're not a match with that investor, right? So before you spend the money to put together a whole series of legal documents, it's good to know whether we're at least in the ballpark and we can actually close the deal. The second piece that a term sheet does, I think, from a more psychological standpoint, is even if it's not binding, you get a level of work and buy-in from your investors. And even though it's not a legal, obligation that you can enforce in a court, getting somebody to commit to a term sheet, I think has a psychological benefit of saying, we're committed to the deal. We like the business. The high level terms are agreeable to us. And I find it's a lot easier to then negotiate the more sort of mundane and sticky legal terms that might come up as part of it. People have sort of bought in to that, and I've seen that happen time and time again. As a lawyer, you sort of I work with some clients that they are bought into the fact that if I can get the 5 high level terms that I need, Joe, just get in there and finish off the rest of it. You know how to protect the company, just go. And for the most part, it's easy to negotiate the last parts of the terms because the ones that are really the most important to you are laid out in the term sheet. And so that can really facilitate the negotiation process. And there are also other people that really like to get into the details. And when you have somebody who's like that, either the investor or the company, a lot of times, like I said, psychologically, people have sort of invested in, mentally invested, not actually in cash, mentally invested in the deal. And I find that it's easier to kind of reach consensus on those. So term sheets, non-binding is the standard. The terms that are binding, or that I find acceptable as far as binding terms, are frequently more sophisticated investors, and this would be VCs and professional investors, will typically include essentially a no shop clause, meaning that if they're going to spend the time to get involved with your company, to do the due diligence, that they want it binding, that for 60 days you're going to stop talking to other lead investors. And this is usually a lead investor term. I would not agree to this with anybody other than a lead investor who's going to have a significant investment in your company. But the key to that is it's not uncommon to have that as a binding term. What you don't want to do is take your company off the market for a long period of time by agreeing to something like that. And 60 days is not unreasonable, in my opinion, to get to a closing. But beyond that, I think that it can really tie you up. The most important thing, and this sort of dovetails into some of the other discussions that you've had earlier in the course, is it's hard for you to raise capital if you're running out of money, and then you all of a sudden find yourself in a situation where you're locked in for 60 days with an investor. That can really impact your negotiating position. as part of that. And so keep in mind that you have to be a little bit, have some thought that this might not actually work out. And if you've got 40 days of cash and you agree to a 60-day lock-in, you better be pretty sure that this investor is going to be the one that we can close with, if that makes sense. So that's just high level there, but that's a term that like I said, I am fine having that be binding, but for lead investors, not for follow-ons. And I can tell you that before I agreed to that, I'd want to make sure that we're pretty well aligned on the deal. Questions about that or anything that I've talked about so far? The other sorts of things that are sometimes binding, you'll have some confidentiality sometimes, although most investors don't like to be locked in with confidentiality. That can come up sometimes. What I would not make binding are things like actual deal terms in the term sheet. So those things should all be binding in a final definitive set of documents that your attorney and advisors review. So questions about confidentiality? Okay, I'm just going to keep rolling. And if anyone has them, just let me know. So what is typically included in a term sheet? So term sheet, are fairly regimented in what kind of terms they have. The first thing is obviously financial terms, right? So what's the amount that we're raising, and what's the pricing or valuation for that round? Now, both of those things have an impact on your dilution, as you've seen when we talked about cap tables last week. But keep in mind that these two things work together. Valuation obviously is what you valued the company before you've raised capital. But don't lose sight of the fact is the more cash that you raise is going to have an impact on dilution. And your investor typically is going to include terms in the term sheet that gives you a maximum amount of cash that they're going to allow you to raise if they're investing in the round, right? Because obviously from their perspective, they want to make sure that they sort of understand what the cap table is going to look like after they finish the round. So this is a common term, not just what the company's valuation is, but typically a cap on the amount of cash that you can raise. And the other side of it is it's not uncommon to have a minimum amount of cash that needs to be raised in the round as part of the term sheet. Now, the reason for a minimum is, frequently investors understand that if you can't raise enough money to execute on your business plan, giving you $50,000 when you really need $750,000 ends up becoming wasted money, right? If they just give you $50,000 and you can go ahead and spend it before you've raised the rest, an investor is going to understand that isn't something that you can actually execute on. And in my experience, and I've worked with companies that have had this, is if you're going to have a minimum raise amount that's much smaller than your maximum raise amount, you need to have a really good story on why you're doing that and sort of what you can accomplish with the lower amount. And I actually find that this is a more difficult kind of planning piece that I go through with clients than the actual amount raised. I've had times where people have had a minimum of 250,000 and a maximum of $1 million, which I think is a huge range. And I think that when you're working with somebody, that story has to match, right? If the story is, look, 250 gets me to build my product, I'd rather raise the cash now to actually go out to the market and market the company and market the product. And the last 750 is quite honestly hiring a sales staff and pushing that out. I think that my product's going to be so great that if we spend the 250, we're going to get to a point where I can prove that the market's there, and then I'll go raise the other $500,000 to actually roll it out. That's the kind of story that you need to have. Or plan that's in place, because otherwise a lot of investors are going to look at that and they're going to say one of two things. Either the company has no idea how much cash that they need, and they're going to see that as a red flag in their term sheet, or they're essentially running out of cash, and they really need 750, but they want to take 250 to keep the lights on and the doors open, just to get people in, and maybe my money isn't as secure as it can be. So that's the sticky part about the amount raised terms. And when you're planning to do a raise, you really have to think through, what an investor is going to look at as part of that, and how that changes the risk of investing in your company. So questions about that, or does anyone want me to delve more into those issues?
Hey, Joe, just a quick question about the percentages of your own business to get a flavor of where you sit really. What percentage are you representing companies, and what percentage do you think that you're on the other side for the investor?
I probably represent 80 to 90% companies and maybe 10% investors. But I have found, Des Moines and actually the state of Iowa, it's funny is how much you run into the same people over and over. And it's, so you have to be a little bit careful when you do that. So I mostly represent companies, but I hope that my reputation as being somebody who's fair and reasonable and sort of knows what I'm doing means that a lot of times I have investors that I think would probably have normally gotten outside counsel that don't, when we're working on deals. But
yeah, I can amplify on that, if you will, Joe. I mean, I can tell you as an investor, when something comes into Plains Angels, one of the earliest questions we ask if we're interested is, who did your documents? And I'm not talking about just the term sheet. I'm not about who formed the company, who did all the work, because if it's somebody we know from the community or from the area or nationally known, our amount of due diligence on the actual documents can go down and can lower our expenses. If we've never heard of the person, we got to go through it line by line, and that's expensive. And in a lot of cases, we'll go, we're just not interested.
Yeah. Thanks, Mike. Yeah, that's true. I mean, it's one of those things this area is kind of tricky if you don't know the lingo and you haven't seen enough of them. And it's funny is that I've had a lot of clients that have used, attorneys who don't usually do this. And for the most part, I find that they've usually spent way more than they have to, and the documents are usually more complicated than they needed to be for that deal. And and frequently they'll have terms in them that aren't common to our market or aren't things that investors want. And that's not too much of a commercial for us. It's just to say, sometimes you don't want to have an attorney who learns on the back of your deal, right? Who tries to figure it out as they go. But most people are also very close to their advisors, and they trust them in lots of ways that are beyond sort of the legal piece. And so I think in our community, it's, people are really willing to help on part of the deal and let you keep those relationships. But I would be a little bit careful, because if you don't know, the learning curve is steep, shall we say.
Yeah, and the other problem you get into, especially with early stage documents, I see this all the time. Well, we only raised 100K in a friends and family round, so we just had my buddy's wife do the docs, and then they go to raise a later stage round, and a VC or a seed fund looks at the docs and go, "You got to completely redo this, because these are just totally unacceptable. We won't sign the deal." So here you were chugging along, doing great, and you're going to raise that $500,000 seed round. And it turns out the documents that were done for 100K friends and family, you save $500. Well, it's going to cost you 2 months and $5,000 to undo and redo and get all the investors to re-sign documents that may say something very, very different. That's a huge, huge problem.
Yeah, that's right. Good questions. So the next question that I get all the time from my clients, and JD can cover his ears as part of this, but they start asking about valuation, right? So what's my valuation? And I only, I jokingly respond by asking them how good of arm wrestlers they are, and they look at me like I'm a lunatic, and that's probably accurate at some level. But valuation, there is certainly science to it. There's a lot of resources that are available. And certainly JD is in a better spot than I am to help you through that conversation. But I can tell you that especially in an early stage company, it's a negotiation, right? I mean, it's like any other product that you're selling. You're selling your company, and you know, you try to reach a number that's based on actual information and things that the market tells you it should be worth. But after that point, it's actually, you know, it's a negotiation that you have. One of the more difficult items that we run into sometimes is if people are really good negotiators in their friends and family round, sometimes they put too high of a valuation because people are, you know, their aunt or their parents or whatever are investing at a much higher valuation than what an actual investor would. And so sometimes that puts you in a position where you have to counsel companies to say, that's great that you know, your aunt loves you that much, but an investor doesn't. And you know, sometimes you find that second round is difficult to get to with a valuation that they've set already. And so we could spend a whole amount of time. The hardest part is engineers, and I see at least one I know on here. Valuation is not a math problem in the sense of it's derived by math, but you know, the engineers that I've worked with always have the most difficult time establishing a cap table and coming up with a valuation, because it's not satisfying from a pure math standpoint. So those are the pieces of advice I would give you is, especially if you're of that mindset, is, you know, at some point you have to come to an agreed upon value as part of this to get the term sheet done. And one of the benefits that I see from a term sheet that's a little bit different is simply putting something on paper that can be passed back and forth with an offer, counter offer, especially on valuation, is really invaluable. I find that when people have a disparity in their valuation between what the company wants and what the investor wants, if you don't start passing a term sheet back and forth, what ends up happening is you have like 50 first dates with them where everyone's excited about the company, and you don't ever kind of mature past that where you actually start talking terms, because you can't reach, you know, it sounds like we're both off the number from each other. And so there is a value, I think, to putting it in writing in a term sheet, because I find that speeds up that process of really finding out where people are. Okay, I'm beating a dead horse, so I'm going to go to investor preferences next, unless people have questions. But so a lot of times with investors, you know, what they're concerned about, and there's examples that you can give that I think are helpful and that I go through with clients. But a lot of times, you know, what an investor cares about is that they, you know, when they come in, they almost worry more about you know, most investors who know what they're doing get into a deal and know that they could lose their money. A lot of the terms that you have in your term sheet are really base hit protection, what I like to call base hit protection, which is, you know, the company does okay, they hit a base hit. The investor wants to make sure that their money is essentially protected on a base hit. So, you know, I'll start with liquidation, which is the most common area that this happens. So, and I think that this is important for companies to understand, is that we all sort of as people, our pain and what we bring to the table is always the most valuable and thing that we have. And an investor is going to, you know, they look at the deal and they say, that's great that you've got an idea and a little bit of implementation, but I have cash, and without, you know, my cash, your idea and implementation doesn't go anywhere. And the company, you know, looks at it the exact opposite way. But one of the things that investors are trying to protect themselves when you're working with them is, if I put in, say, $500,000 into your company, and you turn around and sell the company for $750,000, right? You know, a month later, 2 months later, or whatever, but I only own 25% of that company. And I used a bad example. Let's say I own a third for lawyer math. So you sell it for $750,000, say 6 months later. I don't even make my money out of the deal, because if I only have a third of the equity, you sell for $750,000, I've essentially gotten $250,000 for my $500,000 investment. And you as a founder, you know, you've essentially gotten the rest for the product, which sounds great. You know, you did some work and that kind of thing, but that's unsatisfying for an investor. And like I said, if you sell the company instead of 750,000, you sell it for 7.5 million, everybody's happy, right? But it's those base hits where I find that that's where people end up in a situation they're trying to protect. So one of the most common terms that we have is a liquidation preference, which basically says, look, the investor gets their money out first that they put into the deal if you sell, or, and this is an important or they decide to participate as a common holder, right? And this is one area that I see that I don't want to say it's a mistake because I've done it myself, but for other reasons. You typically want the investor to either choose their liquidation preference, meaning that they get their initial capital out and typically a small return that's negotiated up front, or they choose to essentially share with you as normal. So let's use an example because I think that's helpful. A common term in our market would be what's called a one-time liquidation preference. And usually we have dividends of 6 to 10% that are built in for investors that come into a deal. So what does that actually mean? So a dividend preferred term that we have in a term sheet is each investor gets a built-in return of, let's say, 8% per year, right? And that's, like I said, that's base hit protection. The investor says, I'm going to give you money. I want to have at least the first 8% per year that comes to me if you sell. Plus, I want to get one time my money back out of the deal. And like I said, this is what they're banking on, or they're trying to protect here, is not that you're wildly successful, it's that you're marginally successful, right? And what they're trying to avoid is the example that I gave right up front, where they put in $500,000 and 6 months later they get 250 back while you get 500. Okay, so these terms are common, and I think that they're actually really good for you. The one that you want to stick away from, unless you have a purpose for doing it, is what's called a participating preferred dividend. Okay, so participating preferred means that when you sell your company, they get one time, they being the investor, get one time their money plus the dividend, plus they share in the outcome like anybody else. I have used that before. The times that you use that are if you have a very high valuation and you're trying to protect the amount of equity that the founders have, typically because they see the opportunity as much bigger than the investors do at the beginning. And there's lots of strategy here, but I will tell you that that's one of those things that be careful that you don't go wrong on this term. For the most part, I can tell you maybe a handful of times in my career where I've used a participating preferred dividend for the preferred holders. And we only do it when we're actually thinking about a strategy that we're trying to implement. Okay, so stay away from it unless you really know what you're doing. And this is one of those things where if you find things on the internet, sometimes they are, I think that they're not necessarily the best examples that you can have. I know I've thrown out a ton of terms. I have a hard time knowing exactly where people are. Is that like all gibberish to you? Does anyone have questions? Would you like me to talk through that again, or are people following? Okay.
I think that the examples kind of lay it out pretty well, but it does, and this isn't a commercial, but it does tell you why you really need somebody else helping you with these terms that have been through it before. I mean, even a serial entrepreneur that's been down the road with 6 term sheets can give you a lot of good advice when you're starting out. So just don't do it on your own.
Yeah, because these terms I think can get very confusing if you haven't done them and if you haven't modeled them out. You know, I mean, that's one of those things is if you haven't modeled them out, sometimes you don't even realize what you've agreed to. Okay, so that's like I said, in our market and in most market, you know, one-time liquidation preference, meaning the investor gets all their cash back plus a dividend that's usually 6 to 10%, or they choose to participate as with the common holders, is the most common term in our market. Participating preferred is less common, and like I said, it's used, but it's used in a way that has to be thought through. So, and there are consequences to doing that. Anti-dilution. So there are two kinds of anti-dilution that I want you to understand, and they're typically laid out on a term sheet. But the ones that I'm almost most worried about are the ones that happen before we have a term sheet. So I've negotiated through these many times. The kinds of anti-dilution you do not want to have in any way, I never see it as worthwhile, is I will make an investment in your company. I own 10% today and forever. Okay, so that is an anti-dilution provision, and that is one that you have to stay away from. It will kill your ability to raise money later. I understand a lot of times people, when they give those terms away, one of two things is going on. Either the company is in such dire need of cash that they feel like they have to give that. I would tell you that what I'd much rather you do is have a much lower valuation and negotiate other terms. Or two, the company just doesn't know and they offer this to somebody, usually a first investor. I've had this happen before. I've had it happen with somebody in the market that is, I think, is a reliable investor and who is interested. And before I got involved, they agreed to an anti-dilution provision that was, essentially, I own this percent of your company forever. We negotiated it over lunch that we got rid of it. It cost the company something, and the investor, I think, was, when everyone walks away a little bit disappointed, I think that we've done our work. But I've also seen times that it's totally killed a company. And that's one kind of anti-dilution. The second kind that's not unreasonable and most investors want is, I want to have the ability to invest more money in your company in the future in order to protect my percentage interest in the company. That kind of anti-dilution, it's the same term, but it's got a different provision. So in the first one, they get their 10% without putting any more money into the company. The second, which we never do, the second kind, which is the reasonable one, is I, as an investor, want to be able to participate in future rounds and invest more money in your company. And when we do that, they're interested in doing that because they don't want to be locked out, especially if the company really, goes up in value or goes down in value. They want to be able to participate in those future rounds, either participate in the success or, essentially buy in at lower terms. And we'll talk about those later as part of it. That is absolutely reasonable. And if those are drafted appropriately, I would say that kind of provision is involved in 95% of my term sheets. This is what gets kind of confusing, is because, I'm telling you, one anti-dilution term is absolutely, I never would agree to. One anti-dilution term, I'm telling you, are in 95% of my term sheets, and the devil's in the details to make sure that you have it set up correctly. Questions about that?
Is that the same as a pro rata right?
Yes. Yeah. So that's another term, Mike. That's a good point, Mike. So pro rata right is another term that's used for those provision, which basically means, pro rata means your percentage. And you can buy, basically you get to buy your percentage in future rounds. So yeah, absolutely. Any other questions? Okay. So the next section that you typically have in your,
Joe?
Yep.
Hey, this is Mark. Just one question. If you have the pro rata right, and it doesn't preclude that investor who has that right from potentially investing more than that if you agreed to that, or does it?
No, it doesn't. It doesn't preclude you from agreeing to have them invest more. but it does give them the right to participate up to that point. And there's a lot of different ways to structure that. But frequently you'll have, those are the investors that you'll approach first as people that have already invested. And you certainly could always approach them to invest more. The times that it gets tricky is if you've given pro rata rights or anti-dilution rights to all of the shareholders, then it's possible that you would get into a situation where they start stacking on top of each other and that right continues. That's not common, but it does happen sometimes. But no, you're exactly right. You can negotiate something higher.
Great, thank you.
And as an investor, it's to protect me if a deal is really, really successful. So Mark, if your company really takes off, you may have a VC come in and say, I want to take the entire round and I want the whole deal. And what can happen is because I can't, if that happened, I didn't have anti-dilution rights, this pro rata right to buy, my investment could get washed down to zero. In essence, it becomes such a small amount on the cap table. And yet, if I just invested a little bit more, significant, maybe significant or not, but I can keep my share of the company that's becoming incredibly successful. So it does actually stop. It does exactly what it's said to do. It doesn't allow me to be wiped out due to dilution. And if you're the entrepreneur, you want to take care of your previous investors, but you also need to raise this round. So you're in a bad place. So I think it's actually nice for the entrepreneur to say, sorry, my seed investors have an anti-dilution pro rata right to buy, and that's what it took to get that deal done. So.
Yeah, absolutely, Mike. Being able to point to that, especially because especially if the deal is really good, and even in down rounds, the same thing happens. Is having that negotiated for your investors makes it a lot easier when you're dealing with the new one. It's not you deciding, hey, I need to protect these other investors. It's I've already agreed to it. And that's not an uncommon term to have. Okay. So the next section that you typically have, I'm just looking at my time here. Maybe after this section, we'll take a quick break. So we're going to talk corporate governance. So what does that really mean? That's a fancy legal term for, how we run, how we decide to make decisions for the company. Companies are their own entity. I'm sure that you've heard people tell you that it's like their own person, right? But a company doesn't make decisions for itself. It has to have people that it relies on to make those decisions. And not unsurprisingly, a lot of times more professional investors want to have certain checks and balances on your ability to make decisions for the company, right? They sort of, it's their money at that point that you're deploying, and they want to make sure that certain decisions that you make are reasoned and include them as part of that decision making. So they typically do that with a few, two different mechanisms that are the most significant. And then the third is really just a standard piece. So the first way that they do that is they demand to have seats on your board. Sometimes this is really 100% driven by the fact that they want you to have a board. And so that can be, typically when you have a term sheet, it will lay out, following our round of investment, I want you to have a board of 3 people or 5 people. I try not to go past 5 people, depending on the company and quite honestly, the sophistication of the board members, but they want you to have a board. And so part of it is that they say, I want to have one board seat for the investors and maybe 2 for the common holders. And that's not uncommon to have a majority of the founders essentially represented on the board. But the investors want to have somebody in the room for 2 purposes. One, to know what's going on and to be able to make suggestions to you and fulfill all the duties that board members have. Board members are there as resources to the company to help you make good decisions, to make sure process is in place. All sorts of good reasons for having board members that you're accountable to as a founder, right? And that's really what it comes down to, is accountability. So the board members, piece, people will sometimes say to me, well, Joe, that's great, but I still make all the decisions because we have a majority of the board, which I think is the wrong way to look at it, quite honestly. I think that what you should look at it is the founders have a lot of experience and a lot of passion for the company. And so we do want to have them represented and tied into that board. But a lot of times, investors aren't dumb, and they don't rely on a strict board vote for things that they think are important. So one of the things that'll be done in the term sheet is they'll lay out certain voting and approval rights that you have to abide by as a company, right? And whenever I negotiate those, you have to think through, we only want to have these rights for important things that an investor really wants and that aren't going to hinder the company's ability to do reasonable business. So what do those look like? There's whole sets of them. We're going to talk about them a little bit more in the future, but keep in mind that it's not when an investor wants a seat on your board, they want to be able to help the company. They want to help foresee problems and those kind of things. They're not doing it essentially to protect their decision-making function. They do that in other ways, but do really look at it as, a way that your investor stays engaged and helps you in your success. And if you pick the right investor and they have the right board member, they can be a huge benefit to your company. The times that I see this as a problem, not always a problem, but I think you have to be a little bit careful, is in my experience when I've dealt with actual VCs, they're pretty good about picking board members that are going to help your company while also, protecting their interest. Sometimes when you have large angels who have never done this before, they misunderstand their role on the board, and they act a little bit too much like a principal as opposed to a principal like a school principal, as opposed to somebody who's actually helping the company. And so sometimes I would tell you is like, make your attorney the bad person in that role and have them educate your board members if they have never done that before about what their role is for the company. But the way that the investors from a corporate governance standpoint protect themselves is they will look at your cap table and your board structure, and they'll lay out certain decisions that the company cannot make without going to either the shareholders, including the investors, for approval, or that whoever the board appointee for the investor is has to make that decision. Those are the terms that the investor actually uses to protect their investment. You can't sell the company without our approval. You can't license all of your technology without our approval. You can't, lend money to an officer or a director without our approval. You cannot, buy a Ferrari without our approval. Now, but that's what they're worried about, right? Is that certain decisions that we think that you might make, we want you to justify them to us. And, the thing is if the relationship works appropriately, it is never bad to have a second look at this from somebody else who has more experience in it, especially if you're an early stage founder. I will tell you, and I would encourage you to do this, because I've sat through a lot of board meetings, and the way that you should look at that, especially if the relationship is going well, is, having somebody question your judgment on something is not a bad thing if you're open to the fact that maybe you need to examine something from a different side. So, for example, I used to be on our firm's board, and so I was on that for 6 years, and it was a great training for me on the ideas that, if you come into it realizing I have my perspective, board members have their perspectives and experience, sometimes you realize is that, a problem is more complicated than you think it is, that there are unintended consequences that you haven't thought through. And so your board and your investors really can be a good resource for you if you look at it that way. Obviously, that assumes that the relationship is the right way, but I always work with my founders to tell them that piece is, the board holds you accountable, and the board also, gives you a perspective that you might not have. One of my blind spots as a person is I'm not that, paranoid or cynical. And so when I was on our firm's board, a lot of times I'm like a pretty literal person. I felt like if somebody tells me, hey, I'm doing fine, everything's great, I sort of take them at their word on that. But there are other people who realize, Joe, you might be saying this, but people are hearing this. And I think that perspective is really invaluable. And if you're humble enough to listen to it, it really makes for a better company. So speech done. But that's what I think about board voting and approval is if it's a good idea.
Add something there.
Oh, go ahead, Mike. Sorry.
Yeah. I think that what you have to think about is going over time. So these people are going to be with you a long time. I have investments that are now 8, 9 years old and doing well, but I've been with them a long time. If as an investor or a board member, I've been asked my opinion, and I can see that the entrepreneur or CEOs at least given it due consideration. If something goes wrong with that decision, I don't feel angry about it. I'm not really upset about it. So let's say Joe's the entrepreneur and he comes in and says, I want to do this deal. I'm like, well, okay, I probably wouldn't do it, but here's, have you thought about this, this, and this? Yeah, and I'm pretty comfortable with that. I really believe in the decision. Okay, yeah, it's your decision, right? At least he's asked me. So let's say that decision goes bad. We still have a good relationship for the next decision and the next decision, the next decision. And you have to really think about this as a long term. You're basically married to your investors and your board. Board members can come in and out, but they're still mostly investors. So what you don't want to do is allow your own focus, for lack of a better word, to alienate your investors. Because then when you really, really need them, and I have one case, and Joe knows the deal, has to do with information rights. I haven't heard from them in over a year and a half. They won't return my emails. They won't return my phone calls. And I'm beyond upset about it. And I sure hope that person doesn't call me and ask for help because they're going to get an earful.
Yeah. And that's exactly right. I guess that I was looking at the positive side, but there is a potential negative if you do a bad job of engaging with those people. You have an obligation in that point too. The accountability is a huge part of that. And we all have, we all fall down on accountability. I was actually just talking to somebody the other day, and I think that when they look at that, we as people kind of get into this rut where it's like, once we're too far past, it's not the one that Mike was thinking of, but I was talking to somebody else. And sometimes if we delay doing something, especially if it's hard, it just gets easier and easier to delay. And I think we're all sort of like that. And I think that, with accountability, that's something to really avoid, because once you take money from investors, you're a steward for their money. Right. And I think that, you'll find that most people will respect you more if you have those hard conversations with your investors and with your board members and things. And I do think that you almost get a benefit there when you deal with that. And quite honestly, most of the time, I've had a couple of deals where we've had investors who have said no, and they won't give consent to a deal. And we've looked back later and said, you know what? We probably dodged a bullet with that. And so I think that's, we tend to remember when things work out. We tend not to remember when things, you don't remember the near misses, I guess you'd say. And so that's what their role is. Now, information rights, and Mike has hit it on the head. These are standard. There's information that statutorily that your investors can come and ask for and that you have to give to them. The best way to do it, and I have a number of clients who are very good at this, I have some that are not very good at it, is like the monthly email to investors that says, hey, here's what went well, here's what went poorly, this is what we need, reach out if we can help. I think that does a few things. I've been involved in situations where you have investors, especially non-professional investors who will really, who can take up a lot of time for the founders by asking things that they, it's hard for them to accommodate. But I think if you're proactive and you shoot that information out, and I think monthly is reasonable, I think you can cut off a lot of that, right? I think that I have certain clients that are larger that send out, weekly board quick updates. I think that that's too much for most companies. But I do think that there's two benefits to having those information rights. One, you satisfy your statutory obligation. Two, if it's done right, I think the practice of sitting down and thinking about what you need to update about actually will help you anticipate problems. And three, reaching out to somebody, they might have a solution that you haven't considered, or they might know somebody that you don't know. And so I do think that format can be very beneficial to the company. So that's my feel on information rights. Most of the time, they are more formal in a term sheet. You need to have an audit or not have an audit, have a review of financial statements, you owe me, tax returns by this time, all that kind of stuff is laid out in a term sheet. And I would tell you that most of the companies who do it well actually communicate more frequently than what they're required to in their term sheet. Okay, so I've gone over the first period of time. How much time do you want to take, Mike, for a break?
Why don't we come back about 9:35?
Okay.
It's about 10 minutes. Everybody can take a break.
Great, thank you. So we'll see you in 10 minutes. So so the next thing we're gonna jump through as people come back in is a question that I get pretty frequently. And it's really just a terminology thing. So pre-money valuation gets thrown around all the time. And all that means is you take whatever value you put on the company. We talked about this with the cap tables last week, and divide by the number of shares that you have outstanding if you're a corporation, and potentially could issue from an option pool. And so we'll talk about that a little bit later when we talk about options, but keep in mind that that's, all pre-money valuation is, what shares do you have outstanding, or could you from an option pool or other convertible debt standpoint, and, divided by the valuation divided by that. And that comes out to a price per share that you have. The post-money valuation is simply the pre-money valuation plus whatever you raised in the round. Okay. And so I get this frequently as a question, just because it's a little bit confusing. But keep in mind that the only part that's tricky about this is that increasingly, and in the term sheets, some examples of term sheets, you have things like option pool calculated on a post-money valuation. And so there's some pieces to that I think if you're not good at spreadsheets, there are people who can certainly help you do that, but it gets a little bit tricky. So, the two are not equivalent. The hard part on post-money valuation is it depends on how much money you actually raise. So there's typically some moving pieces that are associated with that. But that's all it really means from those two terms. So I'm not going to ask people if they have questions about it. It's like the most embarrassing thing when people ask me to, clients like talk to you quietly, like, I don't understand what the difference is between the two. And so we lay it out. So I'm not going to ask people if they understand it. We're going to move on. Email me if it does not make sense, or give me a call, and I'm happy to walk you through that. Okay. So we talked a lot about liquidation preference, and I didn't realize that I'd put in an actual slide. But keep in mind that liquidation preference not only deals with the amount of payment, but also deals with the order in which you pay out investors. So if you end up in a situation where you have multiple rounds of investors, you have to think through not only who gets what, but who gets what first as part of that. And so that should be something that, in a term sheet, you lay that out, especially if you have more than one round, how that's going to work. And if you're going to agree to it, make sure that you've actually worked through the math of how that's going to play out for you. Okay, so that's the only, I guess, other point on liquidation preference that I did not make earlier. Okay, unless there's questions on that, I'm going to jump into option pool. And this is one of those, you know, it sounds fairly innocuous, but can be one of those landmine issues that I think that that you need to avoid. And it's more complicated than it sometimes thinks. So you as a founder likely are going to want to establish an option pool for your employees. And all an option pool is the ability to potentially issue equity in your company to certain investors, or I'm sorry, to employees, directors, consultants that you might have helping you with the company. Right. And I could give you a whole nother class on options. I don't want to spend a lot of time on that and get bogged down. But keep in mind that an investor, when they look at it in the term sheet, they will frequently lay out what they want as the size of the option pool. The reason that they care about that is twofold. One, they want to make sure that if they create an option pool, that you as the founder in the earlier rounds take all of the dilution for that before their investment is made, right? And so, you know, a lot of times when I work with clients, there's sort of norms on how the size of the option pool, and really what you're trying to do is figure out how much you're going to need within the next few years and negotiate that. Because an investor wants you to be able to give equity compensation to your employees and your consultants and your directors. But you as a founder actually don't want, there's two things you don't want that are sort of at odds with each other. One, you don't want to have to go back to your shareholders and increase the size of your option pool. And because smart investors and smart negotiators are going to always extract something in exchange for increasing that option pool, because they realize that that's potential dilution to the investors. And you don't want to make it so big that it creates unnecessary dilution to you as the founder and to your earlier investors, if there are any, right? So sometimes, you know, I go through this spiel and you have people who say, well, maybe I'll put a 30% option pool in place. And I can tell you that the problem with that is that all of that dilution hits the founders and the early investors, and not your, you know, whatever investor is sophisticated enough to negotiate this with you. So trust me, when the investor looks at it, we talked about it last week, they're going to look at your cap table on what's called a fully diluted basis. And that means that they're going to assume for their calculations that you've issued every option that's available, and that all of those people who held the options actually exercise and receive shares in exchange. So the bigger you make it, the more dilution you're taking. Most of the time in term sheets now that I'm seeing, especially with investors who know what they're doing, they will calculate this on a post-money basis. And increasingly, I'm seeing investors who ask for unissued post-money availability, which is like a double whammy for you. And so this is one of those terms that I think in a vacuum you can't negotiate, because you need to actually pro forma your cap table to see what happens. But so for example, let me just talk through the terminology. So if you calculate 10% of the company pre-money as an option pool, that means that you know, whatever if you had a million shares outstanding to your actual investors, then it's like adding another 100,000 shares out there, and it reduces your per share value correspondingly. I mean, we can do the math, but that's how it works. If it's 10% post money, that means that the investor comes in. Say the investor buys, you know, 500,000 shares in the company, right? So in my first example, there was 1 million outstanding. We had 10% pre-money, so we had to have an option pool of 100,000 shares. If we did it post-money, then that 10% becomes 150,000 shares that are outstanding, right? Because post-money you have 1.5 million shares. So that number just went up by 50% basically. But also keep in mind that they've even though they've calculated it post-money, all of that dilution comes to the founders, right? Because it happens before they make the investment. The third kind that I'm seeing increasingly is I want to have 15% or sorry, 10% or 15% available post money. So in that calculation, if in our prior example, if you'd already used half of your option pool, right? So you have employees that you've given options to, they may or may not actually purchase those shares. In my prior example, 15 or 10% post money available, you'd actually have like 200,000 or more shares in the option pool that you take as dilution as the founder. And so, you know, there's nothing good, wrong, or bad about it. It's that you have to understand how the math works, because all of it can really impact your dilution as a founder. And, you know, the one piece of the negotiation that you need to be cognizant of is am I actually ever going to use this size of option pool, right? For my development, how would I use it? And the thing to keep in mind with options is if the company is increasing in value, the number of options that you actually have to give out to incentivize your employees should be getting smaller as time goes on, not getting bigger, right? So the number of options you have to give out early to properly incentivize your team is probably bigger than over time, if that makes sense. And so keep that in mind, right? So this is one of those terms that I think it's really easy for you to gloss over if you don't know what's going on with it and say like, oh, that sounds fine. But keep in mind that there's a real, there's an impact to your dilution there that you need to pro forma out. And by pro forma, I mean, put it into a spreadsheet or have somebody who knows how to do that, put it into a spreadsheet and show you the impact that term has, because it can be kind of tricky. Questions about that? All right, let's talk about some other terms that we get into in a term sheet. So sometimes you might have terms that are already written into a term sheet. I find that when these kind of things are in there, whoever your investor is has been burned by them and wants to make them very specific up front. You know, things like founder salaries. I like that show. I like Mike Judge a lot, and I like Silicon Valley. And I find that it almost hits a little too close to home, some of these things. But you've got the one where the guy gets the Corvette and then sells it to to Jin Yang or whatever. And it was one of those things where it's kind of a joke, but kind of not a joke. Is like you don't want to dump a whole bunch of cash on younger people who have not had that amount of cash and have them in their mind thinking, you know, I'm going to go, you know, blow this in some way. It's not their money, it's the company's money. And so a lot of times, you know, it's a cynical standpoint from the investor, but it also is, I think, helps to kind of expectations set that for a founder, this is not like, doesn't really become your money, it's the company's money. And so I think that is one of the reasons that it's in there. You know, like I said, it sometimes gets put in, it sometimes doesn't. I think it's reasonable to set those expectations. Oh, sorry. I'm going to move my thing here. You know, there are also things is that you know, there might be like large decisions that they dictate, you know, essentially how you would handle that, like major purchases and those kinds of things. Sometimes in term sheets, they'll say things like, you know, the founder or the board can make decisions up to 50,000, but after that, they've got to get some kind of level of approval. This, I think, is just expectation setting. Increasingly, it's coming in term sheets, and the reason that you put it in a term sheet is, you know, the investor knows that they're going to negotiate that later, and they don't want to have it seem like a surprise or feel like a surprise to you, is why it makes it in there. One of the things that I find that happens all the time, and this is actually one of the most difficult conversations that I have with my clients is over vesting equity for the founders, right? So if, I always recommend that founders vest their equity amongst each other, right? And I've just been in too many situations where over time where, everyone is on the team is not in favor of vesting. And, despite what I tell them is it keeps each other honest, it, is good for morale, because the last thing you want is a founder who walks out the door who has the same equity percentage that somebody who's toiling away on the company has. There's a lot of reasons why on the team having vesting terms makes a lot of sense. So I always recommend it, and I'm fairly successful at convincing people that it's a good thing for them to have. But one of the harder discussions you have is then an investor who comes in and you're 2 years into your vesting schedule, and the investor comes in and says, that's great, I want you to revest that equity over another 3 years or however long. And the thing about it is that the answer I typically get is from the founders is, well, I've already done that, why am I revesting? And if you look at it from the investor's standpoint, most of the time, they're only investing in the team that you have. Your IP has some value. The things that you've developed have some value, but that value gets eroded, if not erased, if the team isn't there. And so, prepare yourselves, it's going to happen. Investors, when they come in, are going to negotiate those kind of terms on revesting equity. Almost always happens. Now, I can tell you that the kinds of things that you can negotiate frequently are, I've developed this much of the product, I'm only going to vest half my equity, or, a third of my equity, or, I'll take some options and maybe those will be vested in a different way and only 20% of my equity is vested. Those are the kind of negotiations you can have, and those are productive. For lack of a better term, pouting and stamping your feet with the investor is not going anywhere. Because from there, like I said, it should be flattering, right, to you as a founder, is that they see the real value as you. And I just think that it's a hard discussion. It's hard to hear. It's not something that most founders like to go through, but it's a reality and it's going to happen. And so prepare yourself for that piece. And there's real reasons why, from an investor, that they need to have that happen. Now, that having been said, it doesn't mean that you can't, negotiate parts of that, but I would not demand that they remove that entirely. I think that that's going to show that you really don't appreciate the position of the investor, I think. And I've just been through this enough times. Maybe it's recent on my brain. I've done this recently with a couple of clients. I just don't think it's, from a strategy standpoint, makes sense to say no or to fight on this. It's going to be there if you want the money. I think it's much more productive to kind of have good reasons and push back on pieces of it, or adjust the investing schedule, or have those kind of conversations. But it's not worthwhile, in my opinion, to say no, because, like I said, the investor really needs that to be confident that you're going to be there to kind of push it over the edge. Questions about that? Okay. Yeah.
This is Joey. So
Yeah.
the point in that, really, and I guess I'm asking from an investor standpoint, it's to make sure that the founders who have created this thing and have all the key knowledge are going to be around and don't have a incentive to take off. Correct.
Yep. You want them tied to the company until it's worth something, right? And so from an investor's perspective, frequently, and I've seen this, people, they create IP, they create companies and those kind of things. And, there's a reason banks don't come in and lend money to these companies, right? Is that if you default on the loan, the bank doesn't know how to come in and run your company. Your investor doesn't know how to come in and run your company, or they don't have the wherewithal to do it. And so, so that's exactly it. To protect yourself, you want to make sure that they're there, or that if they decide to leave, that they don't, that there's a disincentive to them leaving, right? And I think that it's especially important when you have other members of the team, because I think it's a huge morale killer. I've had several situations where people have not had vesting or haven't vested all of it, and somebody walks out and you have the conversation, usually on a Friday afternoon at like 5:45, when they're sitting there, trying to asking you questions about their investor update. And then they start saying things like, yeah, Tom was, he and I have the same percentage in the company, but he's off working for Dell and making a ton of money, and I'm sitting here working on this update. And I've had those conversations. And so I think that it, for morale, it's good to have that there, because you don't want the team to have the disincentive. And for the investor, it also protects your investment. Good question, Joey. Anybody else? All right. So we talked about this.
I just reemphasize that, and I've seen this on the entrepreneur side. You don't know when one of your co-founders is going to leave on you, and even stock that you're handing out to key employee hires, you just don't know. And people, especially when things get a little tough, people do not so great things. And I've seen founders give stock to a new employee, even someone that they knew well and were friends with for years, didn't vest it, and the person didn't do the work and ended up owning a bunch of the company, and that founder had to go buy that stock back. They literally had to pay the person for not doing anything with money they could have invested in their company. And I mean, that's happened here in town.
Oh yeah. Go ahead, sorry.
And I don't want to take this direction that's not intended, but are there some things that should be put in place along the same time to help protect the company from some of those key employee issues?
Yeah, so Tim, oh, sorry, go ahead, Joey. I cut you off again. I apologize.
No, actually, I was just adding the founder to the key employees.
Yeah, so it's best practice, and I would say necessary for them to as I keep talking about that vesting piece, but typically I'll do a founder agreement that'll have vesting of the equity, it'll have non-compete, it'll have confidentiality and non-solicitation terms in it. And those are, and IP assignments are always kind of in the same agreement. And so what that does is it protects you to know that, the founder or the key employee, if they invent something great, that they've assigned it to the company. It makes sure that they aren't off, that they have a restriction so that they can't go and work for a competitor after they've learned, all of your customer lists and those things. It provides all sorts of protections. And, the thing about it is that I think every member of the team should have those in place. And, for nothing else than the fact that you need to understand that the company is investing in you and has a vested interest in the things that you're doing as part of the company. And so I've certainly had tricky situations we've worked through with those where, people haven't had that in place, and then you have to negotiate it later, because smart investors make sure that you have those protections in place. I'm going through one right now. I actually got a text like 30 seconds ago. It was funny, on this exact issue. And it was one of those ones where, we're trying to negotiate those kind of terms, but after the fact, and it's really difficult to do. So I would tell you that I think it's in everyone's best interest. And I tell people typically when I'm negotiating this, you never know who the person who's going to walk out is. And so long as everyone's on the same page, and we're all in the honeymoon stage with each other, that's usually the most important thing. Is it might be me, but it might be you. And so let's all have the same rule for ourselves, and but let's get it in place ahead of time.
I would add to that you're talking about people that do startups as being really creative people that create stuff. And, we got a lot of engineers that are absolutely amazing at what they can do, but they don't stop thinking once they work on one product. Okay. And I'll pick on Aaron for a minute. I know him a little bit. Aaron's got a really interesting product he's working on. He's a very talented engineer with a lot of background. This won't be his last idea. But while he's working on a company that I'm a major investor in, I don't want him working on those other ideas unless they're going to benefit the company. So if he says, gosh, this idea I worked on for 5 years, now it's just running a business. It's not as exciting as working on the next idea. I need him to work on the business. So I've got to make sure that he understands if he does come up with something new, and let's say on his evenings and weekends, he invents a whole new way to do something, that's really got to belong to the company, because that's time that I assumed he would be working on the current company. Sorry to call you out on that, Aaron, but it's just a common thing with really, really talented people. They have great skills and they are creative, and that's what you're investing is that creativity. It's just, you have to understand the other side of it.
I have a question. What would be the typical vesting schedule? And what, for example, if you hire an employee, give them some stock, but half a year later you realize that this is the wrong employee and you want him out, but he has some of the company. How do you deal with that?
Yeah, so the common in our market is what's called a 1-year cliff, meaning that the employee doesn't vest anything during the first year. And that's like larger companies would call it like a probationary period, right? And so if they leave or you terminate them during that year, they vest nothing in the company, right? That's pretty common in our market. And then the vesting schedule is usually equally over 3 or 4 years. Those are the most common. I personally think 4 is more reasonable. Most companies, as Mike kind of pointed out, they don't exit in 3 years like people think, right? And so 4 years, I think, is a more reasonable period of time. I've had other ones that have gone even more than that. But typically what happens is the cliff term that I have is they vest nothing for the first year, but if we do a 4-year vesting at their anniversary a year later, they've vested 25% of what they've gotten. So your next question then is, what happens if they are in my company then and they are, they're out as an employee? I've terminated them as an employee. Most of the time they don't own enough in the company where they essentially, they become a shareholder in the company. They've got voting rights. If the company sells, they get their part of that. But I'm not in favor of making those like non-voting shares, because I think most of the time it just doesn't matter from a percentage wise that they do that. But if they're going to be a major investor, a major employer, and they're a big number on your cap table, and you think you might fire them, we can always negotiate ahead of time a buyback or something to get them off the cap table. But I personally think that that's a disincentive, and quite honestly, I think that can go bad for the company as well as it can go well. And so, I'm not in favor of it in most instances, and in my experience, I think that it's harder to negotiate than anything else. Mike, do you have perspective? You unmuted.
Yeah, I just was going to say, I think the other thing is that if, let's say, that I work for you and I had 2% of the company and you had to fire me for whatever reason, there also should be a part of the agreement that's pretty standard that says if I want to sell those shares, I have to make that offer to you first.
Yeah. That
I can't just run over because I'm angry with you and sell it to somebody that you won't like. And people get really emotional. It's what we are. We're emotional beings, and you have to protect yourself from that.
Yeah, we'll cover that, I think, in a later slide too. The right of first refusal is very powerful for these companies. Natalia, did that answer your question? Okay.
Yes, thank you.
Yeah, absolutely. Okay. So as we talked about before, board members, keep in mind that the voting number is not what they want. And so, but typically the term sheet will lay out if they're going to get a board member as the investor, you'll lay out how many board members. And typically, if you can identify who that person is, that'll be part of the term sheet as well. As we talked about before, I apologize. I think I went through a lot of these before, but there are certain investors will negotiate for certain decisions that they have to consent to. As we talked about, that there's some benefits to doing that as well. Keep in mind that you want to make sure that you keep these to really important decisions. And sometimes I see this as most professional investors kind of understand what those bet the company kind of decisions are. The last thing you want to have is something where you constantly have to go to your shareholders for consent for that are not significant issues. If I see an investor who wants that, I try to typically move that to a board member decision, because the last thing you want to do is track down like shareholder signatures, go through the investor's attorney if they have one to get consent to things that are small. My experience is sophisticated investors know what those big items are, and they don't push for more. Sometimes when people find term sheets who are not as experienced of investors, that's where we get into these problems where they become a real roadblock, and it's for things that don't make that much sense. So when I say carefully consider the lists and the thresholds, for example, if you're a company and you have a provision that says I have to go get shareholder consent every time I spend more than $5,000 on something, I would tell you is like, if I as your attorney have to get involved and negotiate this, every one of those transactions is going to be $500 at least to get through the fight of it, right? And so I would tell investors that those thresholds are pretty important. For most companies, if you're going to spend more than $100,000, $200,000 and you're an early stage company, those are the kind of things that your investors are going to probably want to have some consent on, or at least their director. But make sure that you have a reasonable number there. Just because it ends up becoming a problem that it just takes time to get through every time. You can't be as nimble as you'd like. And if that number's too low, it impacts your ability to run the company. So keep in mind blocking versus affirmative rights. So affirmative would be things that they, pro rata rights, things that they get something for. And that would be things like, their preferred dividends, liquidation, things. There are those affirmative rights, but they also frequently will include things that block you, that say you can't do this without this happening, and make sure that you understand how those work together. The last piece, and this is one where I will tell you that I think is an increasing issue that I try to put in if we can negotiate, is a minimum ownership requirement in order to get certain rights. What we want to have is we want to make sure that there aren't people that sort of ghost the company, that all of a sudden have some consent right because they were an early investor and we gave them a consent right, and then all of a sudden we can't find them, or they don't answer email, or those things that you want to have. And so frequently what happens is that you'll include a provision that says that they have to have some minimum amount of the company in order to maintain those rights. And I think that's, if you plan correctly, it doesn't come up, but do think about that, about whether you want to give this right to everybody or whether you only want to give it to certain larger investors. And those blocking rights, I think, are prime for the kind of ones that we say those should just be the larger investors. The affirmative rights, for the most part, I'm less concerned if everyone gets them, but it's the ones that can slow the company down that I think are you have to be a little bit careful dealing with. All right. So management information, we've talked about that. Some of the common ones that you'll see are, periodic financial statements, monthly, quarterly, annually. Those are the kind of things that you want to make sure that you're in a position to deliver them. If you're an LLC, a tax return filing by a certain date, that might seem petty, but if you're trying to pull together your own tax return and you're waiting on an investment to send you their tax return, that can be it can be a huge headache, and so those frequently get worked in. Budgets, a lot of times, are things that larger investors are going to want to look at. I look at that as two things. I mean, a budget is, especially on the expense side, is really important for companies to show good cash management. And I would tell you that your investors, if they're being helpful, might look at your budget and say, does it really make sense for us to do X? Are we getting the value out of this expenditure? Those kind of things. I think that there are, good investors who are sophisticated, can bring a lot of experience and help you with that in a good way. And so I don't think that I encourage my clients not to look at this as, some insulting thing. Your investors are trying to make sure that you're successful. Their success is tied to your success. And so I think you should take as much input as you can on those. But a lot of times that's also required by your bank. If you have a bank and those kind of things, they want to make sure that those kind of blocking and tackling issues are taken care of. But when you have these, make sure that you carefully consider what you've agreed to and that you can actually use or deliver those, and whether they're going to block your company. So for example, if you're a very early stage company, a lot of times going through an audit process is expensive and time consuming. And it's one of those things where if you don't have to agree to have an audit, I wouldn't necessarily do it. But I'd also tell you, if I was an investor, I am more concerned about the ability to come in and sort of self-audit if I think that there's something going on that's strange, if you don't have an audit, right? So those are the kind of things where, as an investor, you want to push for the idea of looking at it and saying, can I protect my investment and make sure that it's going well? From the company's standpoint, they want to look at the same term and make sure that A, they can comply with it. Do we have the wherewithal to do it? And B, is that create some problem for us that we can anticipate and avoid? Okay. One thing we talked about a little bit before is operational decisions, or things that you're going to need to have a quick decision on. I try to make sure that those are made by your preferred director. So for example, if the investor has the ability to appoint a director, instead of having the shareholder, so the investment fund or whatever, make that decision, make it so that the actual director has it. Frequently, it's quicker and easier to get that person to consent than it is to go through a shareholder consent. So that's just, for me, anything that needs to be done quickly, you have to think through how you're going to get that done. Same issues, blocking versus affirmative rights that we talked about before, and minimum ownership levels. I don't think I need to go through that again. Mike brought this up before. Right of first refusal is common in most companies. And what this does is it means that if investors want to sell their investment to a third party, they have to offer it to the other shareholders in the company before they can sell it. This is especially important for early stage companies and companies that have very few investors. And the idea is that you don't want to have somebody end up on your cap table that you don't like, or that you can't get along, or in Mike's example, that was a spite sale or a competitor or somebody that, that you really don't want to, there's some reason why you don't want to. And keep in mind that there's two pieces to this. It doesn't mean that your shareholders can't sell to some third party. It means that you and the other shareholders in the company get the right to essentially match that deal. Right. So that's why it's fair, is that you get to match that deal that they got from the third party. But the reality is that it also, it does arguably depress the value of those shares if you have an investor who says, I really want to buy these shares, but I might go through all this work and then find out I can't because the company bought them back. And so keep in mind that they're, putting some kind of minimum ownership level in there. That's important, especially as you get more people on your cap table, might make some sense. But I think this is a standard term. I recommend it for all my clients, and it gives you the ability to kind of block those transfers by buying the person out, which can be invaluable for you. Okay. So drag along and tag along rights. I would tell you that these are for the most part are added to most term sheets that I've been seeing by more sophisticated investors. I try to avoid them early on in companies when I'm working with them because they add a lot of complexity. A lot of people don't understand what they are, and they don't get triggered that much. But so drag along rights, essentially, it requires shareholders to sign off on like a sale of the company or other exit transactions. So it doesn't let them hold out to do that. For the most part, it's what it really does is it makes available certain sales structures that might not be available if you don't have the drag along right. So most of the time you can, if you want to sell a company, you can do it through a merger or an asset sale, some other legal structure that without having this drag along right. But the reason that you put it in there is to have all your options open. And I actually think that this is more important than the tag along right, as we'll talk about in a minute. So that's all it means is it's just like the name sounds. You're dragging somebody along in agreement on a sale that probably is going to happen anyway, and it makes it easier to close that sale. So from an investor standpoint, it, like I said, it opens up options for everybody else's perspective. In my opinion, you're not giving up anything so long as the vote it requires to approve the sale is high enough. And I can give examples, but that's my basic feel on it. Tag along rights are a little bit more difficult, and actually I think have more of an impact on value. But what it's designed to do is if a founder, especially a founder, usually it's drafted, like all these, they can be drafted in a lot of ways. It prevents people from stranding the other shareholders in the company, right? So if I'm a founder and I own 50% of a company or 45% of a company, and I get a really good deal to sell my shares to some third party, it allows the other investors to essentially go along and sell a proportionate amount of their shares in the same deal, right? And so for larger companies, that might make sense. In my career, I've never had a tag along sale that's gone through. Most of the time when you get a good deal, the person who's acquiring wants to buy the whole company, or they want to buy, they essentially won't agree to a deal where they buy the founder out and leave everybody else in. I might not remember one, but I've always, every time I talk about these, I try to think of the last time that I actually had one that went through. JD, have you, I don't know if JD is still there, but have you done a tag along sale with anybody? You probably have, but
we have. It was more of one that was already inherited, Joe. But yes, I have been involved in one.
Yeah. So I just have. It's one of those ones where it's asked for frequently. I just haven't. I just don't think it's as important. But like I said, it gets negotiated in. I tell people, so long as it's drafted appropriately, I don't fight it because, like I said, it's almost never come up in I've been doing this for 14 years. But it is one of those things that gets thrown in there, and it could come up. So, questions about that? All right. One more anti-dilution things to keep you on the tip of your toes. So we talked about anti-dilution in the pro rata sense, meaning that people get to buy their interest. One of the other things that investors will ask for is anti-dilution protection that protects from down rounds, right? So if you remember when we talked about the cap table, the impact that a down round where the valuation comes from a higher number to a lower number in the company can have a real impact on value. There's two predominant ways that this gets handled by investors, and this is a terminology thing, and people, I get a lot of questions about it, is a broad-based weighted average protection, and that is acceptable. We agree to that all the time. All that means is if you have a down round, it essentially, there's a formula that says that the investor gets protected and essentially gets to a larger percentage of the company if you have that down round. You typically max that out at either one round or some period of time, but those are fair. They're more fair than the other alternative. And there's a formula that's available, and the only way to really understand it is to kind of pro forma what would happen if you have a down round. The second type is called a full ratchet, and all that means is if I raise money, say at $2 a share, and the investor invests at $2 a share and say they buy 100,000 shares, right? And then I have my next round of financing, I raise money at $1 a share. I have to go back and give that old investor the same price for when they invested as they get now. And so that essentially instead of having 100,000 shares, they get 200,000 shares immediately for putting no more money in. And it's a hedge for them, because if you have a down round, it essentially means it acts as if they had put their money in the down round. Now, I'm not saying I would never agree to it, but they'd have to give me some pretty good incentives on other terms in order to agree to that, because what that does is it gives them the ability to essentially cut their risk significantly that you hit a stumbling block in the company at some point in the future, right? So the same thing happens with issuing a bunch of warrants. There's a whole bunch of other things that I'm starting to see more and more in these, but keep in mind that these anti-dilution rights, you have to work with somebody who knows what they're doing and make sure that you understand how they work. Like I said, the broad-based weighted average is standard and I think is fair. Full ratchet is not something that I would recommend that you agree to. All right. Any questions about that? All right. Right to participate in future rounds. We talked about that a little bit before. One of the other terms that sometimes you'll see in these term sheets is a right to receive the same rights granted in the next round of financing. So if I put my money in today, I get the same rights as somebody who puts their money in 12 months from now in a separate raise. This is different. So let me give you a little bit of background. A lot of times when I'm working with clients, we will negotiate with investors, and the investor, we'll close like 3 or 4 investments with people on a certain set of terms. And then we're trying to close the whole investment, and we get somebody else who comes in and says, yeah, I really want to invest, but I think your valuation is 10% too high or whatever. From a purely legal standpoint, you can agree to a different term with different investors in that round. That is a bad decision from a business standpoint and from an investor relations standpoint. So my recommendation is always, if you get halfway through a round and you negotiate a different deal with somebody else on price or some material term, I think it's best that you give that to everybody else in the round. Yeah, I think it's one of those things where, if you don't do that, I think that you have investors who are irritated by that or potentially are irritated. And I think it's a sign of goodwill to your investors to do that. That is different in my mind to somebody who says, look, I want to have the same rights that you might give in the next round of financing, because that next round could be 12 months later, 18 months later. The position of the company could be different, and the investor might be bringing something to the table that's different than the current investors. And so I don't think that I don't think that you should automatically agree to that. I don't like that term. And I typically back that up by saying, you know, look, investor, I'm not going to give you this, but you've got pro rata rights. So if you like the terms of that next offering, you can participate on those terms. But I don't like to automatically give it. That one feels more like the full ratchet that we talked about before that I don't really like. But keep in mind that this does get put in sometimes, and like any other negotiations, you sometimes need to pay attention to that, and sometimes you have to agree to it. But that's one that I push back on. Questions about that? Okay. Another thing that's increasingly happening is when you get these term sheets is that they'll dictate what legal forms that they're going to use. There's some standard legal forms that people use for most of these rounds. I think that this is a great thing. I don't have any problem with that. And a lot of times, if there is a term like that, it's always a good idea to pull those forms out so that you know ahead of time, is there some other thing that I see in these that we should put in the term sheet as opposed to waiting to negotiate them later. So I think that this is actually a good step, but keep in mind that that make sure that you understand what those forms are, and make sure that there isn't something in there that you want to negotiate up front as opposed to waiting to when you have a whole bunch of money tied up with your attorney and we're negotiating something we could have talked about before. Does that make sense? All right. All the rest. See, this is great when you get to the end and you say, all right, this is all the rest of the things that we have. Intellectual property and assignment of inventions. We talked about that before. Investors are typically going to want to have that laid out in the term sheet, that you've already got that in place, or at least make it a condition of closing. And so, having that in a founder's agreement is really helpful. Confidentiality and restrictive covenants, those are the same things that we talked about in the founder's agreements. And a lot of times in the term sheet, the investor will say, you have to get this taken care of ahead of time. Employment agreements, if they want you to have certain employment agreements with employees, key employees, other people who might not be founders but are important to the company, a lot of times these get thrown into the term sheet. It's for nothing else than to tell you, hey, before I close, you need to go get this figured out. And for the most part, I think that those are usually good suggestions that help you with the company. The final piece is reimbursement of costs. So this is standard now for larger lead investors, where they negotiate ahead of time to say some amount of the cash that they're going to invest goes back to reimburse them for legal costs and due diligence costs and those kind of things. It's standard in certain term sheets that like the Cooley Go or the National Venture Capital both have a term in this. Here's the key to it, I think, is in a way to kind of keep us all honest in our negotiations, I like to make it so that reimbursement only occurs if you close the round. So that's a little more incentive to the investor to, especially if we get to little nitpicky negotiations, that they know that we're only paying those negotiating costs if we close, as opposed to if we pay them regardless, right? And so that's one tweak that I always put in, is make sure that it's only paid if we actually close the round. And I would say the common number, especially for depending on the size, is between 5,000 and 15,000. I think the Coast funds that I'm dealing with are mostly 15. If they go over that, I typically, especially since we've already agreed on the form of the documents, and especially if we being the company's counsel is going to put the documents together, I think that that's the max that I would agree to, unless it was a really big and complicated round. But keep in mind that those are becoming more common, and I think it's appropriate just for lead investors, not for follow-ons who are relying on somebody else to do most of the due diligence and legal work. But for the most part, I don't have a problem agreeing to those, so long as the number's reasonable and it's only paid on closing. Questions about that? All right. So final thoughts, Mike put this together. We've got some links in there. I think he made available in the chat some of the documents and things and our contact information. I will tell you, so I'll stay as long and answer whatever questions people have, or get in touch with me if there's things that you want to talk about. But I'm happy to answer those questions, and I appreciate your attention today. Don't hesitate to reach out to us if we can help with something.
And I would just add, pretty much all the documents from this seminar are on the website. That's that first link, dsmpartnership.com/raising capital. I will tell you that today's video hasn't been put up there yet since we're still recording it. You have today's deck, you have the latest appendix, but the rest will be updated probably tonight or tomorrow. And stay in touch. And to Joe's point, I mean, my role is to help startups in the community. It's paid for by the partnership. Take advantage of it. We don't charge. We don't want any money from you. Just want you to succeed. So I will just say thank you to JD and Joe. Also, thank you to Charisse, who's here with us today. You guys were all great presenters, did a wonderful job, and I just really appreciate it.
Thank you, Mike. Thank you to you as well for coordinating everything. And Natalia, did you have a question? I saw you unmuted.
Yeah, I have a question about liquidation preference. And you were talking about payroll order for the investors. Why payroll order makes a difference? Why is that important? Is that means that whoever is paid last might not get enough money, or?
Yeah, so there's actually a legal order that you have to pay. So if say I'm a company and I sell, which is the best case scenario, I have to pay all my liabilities. So if I borrowed money from a bank, or if I borrowed money from an investor, it's not equity. Anybody like that I do business with, you have an obligation to pay them first. And then frequently, and then if there's money left over, then the standard is that you split it among all your investors based on their percentage ownership in the company. But a lot of times the investors want to say, okay, I don't like that rule. You can pay your liabilities first, but now I want to be paid first before anybody else. And frequently what happens is the preference gets set up as the last money in gets paid out first, right? And so it typically would go, the last investors, we pay all of them out first, their liquidation preference. Then we pay whoever the more recent investors are who have this right, and then everybody else gets paid last. And if there's, if you get to that point and there's not enough money, you either get nothing or you get a percentage of what you're owed. Does that make sense? Mm-hmm. And so that's why investors want it, is that they want to jump ahead of everybody else, or at least have the right to if we do it. Now, keep in mind, if the company goes out of business or fails or whatever, nobody gets anything. And that's why I kind of, so I'm guessing, Natalia, that you didn't grow up in the United States. So when I say base hit, it's like a baseball reference, like it's okay, but not great, right? So does that make sense? Sorry, I realized you asked that. So it's like, we do okay, but we don't do great. Like nobody gets rich off the deal. That's the times when these become important, right? Is that they want to be paid first. So.
Okay, thank you.
Absolutely.
I have a quick question about maybe, when you're dealing with inexperienced investors, I know a lot of us last week mentioned we were going through friends and family rounds. Uh-huh. What kind of pitfalls do you run into? Because I can see it going both ways, where somebody is, being unreasonable with terms, but also there's those that, won't even read the terms and not understand exactly what they're doing.
I would tell you, for friends and family, I try my hardest to make them come in as common shareholders in the company, meaning that they have no more rights than you have. I think the pitfalls are that you give away rights that you didn't have to give to them, meaning that they didn't read it, they didn't care, and so they're investing because of some relationship to you. It's not primarily a business transaction. Those people, I would try to keep them as common. If they do want preferred, I'd want to make sure that we're giving them just what they need or want to have. And sometimes it's hard in those. The pitfall is that you have a personal relationship with those people, and so in that sense, I always try to blame your lawyer, blame your accountant, and say, I'd really like to keep you happy, but they keep telling me that it's a bad business decision. The other thing that I think is a real pitfall is negotiating too good of a deal to the company, as strange as that sounds, and then having those people have certain rights that, like you set a high valuation and they have certain rights if you go out and raise at a lower valuation. I think that can be a pitfall. Those are the times where we renegotiate with investors, and quite honestly, it sounds crazy to say that, but I've seen that happen a few times. And they have certain, we talked about down round protections or whatever. We've given that to somebody who then turned around and negotiated a terrible deal for them, and then all of a sudden now we have a real investor, and it's almost like we have to negotiate against ourselves on that. I know that's it seems like it shouldn't happen, but it does. And so that's usually grandparents and things that they're like, yes, this is a $5 million idea. I don't know, my grandparents didn't talk like that, but that'd be that kind of thing. And so that can actually work against you. Does that make sense? And then complexity, just any kind of complexity. Like I said, if you can bring them in as common, I think that's the best way to do it.
Yeah, and Joe, what we've seen too, a lot of times the biggest conflicts are that round, friends and family, because they tend maybe not to be that sophisticated or educated of an investor perspective. And if too much is given away, or sometimes if they don't even read the terms, they don't understand that they can be diluted, all of these types of things. So it is keeping it as simple as possible at the friends and family level.
Yeah. And for your benefit too, is like, some level you might, it's very difficult to have business relationships sometimes with your family members. And so make sure that it's the kind of person that understands what they're getting into, understands the investment. I think we talked a little bit about this last week is, if somebody expects that they can get in and out of these things like they can a mutual fund, they're the wrong investor, even if they're related to you.
It's really important to let them know they can lose their entire investment. I mean, I look people in the eye and say, you understand you can lose everything on this deal, that you'll get no money back. Yeah. And you have the ability to lose that money.
Yeah.
Thanks. What about like board seats for people like that?
I would avoid it. If they can't bring something to the table, I don't want them on the board. I'm okay, you give them information. I just think that, the problem is board seats you don't want to fill them up with people that don't, and it's like all the things, like if your investor is like really has some value, they know your market, I wouldn't give them a board seat just because they gave you some money. And quite honestly, with those people, they should trust you enough, if it's like real friends and family, that I'd lean on that a little bit. But I don't like having boards full of people unless we can get rid of them, right? Because you as a company need to have a board of people that can actually like help you, open up doors for you, give you good business decisions. And friends and family typically are not like that. They're still mad about you crashing a car when you were 16. That's probably not the right person to have you on your board. Like, Aaron, I'll tell you what, I'd trust you, but I remember when you and your friends went, whatever.
That was my brother, so they don't have to worry about
that. That was your brother? Yeah. Well, well, then you're probably fine then. Just throw them all on the board. I'm just kidding.
Thanks.
I'm just kidding. All right.
Quite honestly, Aaron, at that level, you probably shouldn't even have a board yet. At the level you're at, if you're still friends and family, there shouldn't really be a board.
Yeah, that's what I was wondering.
Yeah, you have a board of one. Don't put.
So I'd like to keep it. Yeah, no,
Don't put
no way.
Kirsten on your board.
No way.
All right. Well, hey, if people don't have any other questions, I think our contact information is in there. Feel free to reach out. I appreciate the time and attention, and I hope that you got something out of it, and have a great rest of your day.